Welcome to the Wednesday pretest video, last one of the summer quarter, as the test will be going out tomorrow at noon. There will be a makeup question covering the libel, privacy, and news gathering torts, same system as with the second test. If you do better on the makeup question than any one question you did on the second test, I will substitute question for question. So let's get into the questions you had about the materials to be covered in this exam. A lot of them dealt with access. And the first question I had in your blogs is about Exemption 4. This is the trade secrets exemption. You'll note that the student has correctly pointed out that Exemption 4 does not apply to patents. Patents are protected under a different law entirely. They are of limited duration, whereas a trade secret lasts as long as it's secret. So students' question is, how is it officially recognized that a secret is no longer a secret? Well, it doesn't have to be absolutely secret, but you have to have commercial privacy. Companies have to take steps against espionage, but trade secrets can be shared by agents, employees, and others who would normally be expected to use the information. So if your trade secret deals with 11 herbs and spices to make Kentucky Fried Chicken, and you work in the plant that combines the spices, then you would be privy to the trade secrets, or at least half. For Kentucky Fried Chicken, they have the 11 secret herbs and spices. Half of them are prepared in one plant, half are prepared in another plant. They ship them to a third plant, which just mixes them together in order to get them to the individual KFCs. So that's still a trade secret. And of course, Coca-Cola, probably our most famous example. The Coca-Cola formula is the key to the company's soft drink success. And the Coca-Cola formula is a trade secret. Now, if you go online and Google or use another search engine for Coca-Cola formula or Coca-Cola recipe, you'll find a bunch of sites that say this is how you make Coca-Cola using these ingredients you can find in the regular American kitchen. They may even be correct, but the Coca-Cola formula is still a secret. It's still a trade secret, and as long as they keep it a trade secret, then it'll be protected from disclosure under Exemption 4. Now let's talk a little bit more about when something is not a trade secret. Remember, if it's a trade secret, then a company can go after you for trying to divulge the trade secret. You can be prosecuted for crimes committed in trying to acquire a trade secret. When you do, one of the defenses raised is that, well, I didn't do anything bad because it's no longer a trade secret. There, the courts will take a look at how many people know the trade secret, how widely it's been disseminated, whether the company has taken steps to preserve the confidentiality of the secret, and ultimately it will be a court that determines if something is still a trade secret or not. Exemption number 6, personal and medical records where the disclosure would constitute a clearly unwarranted invasion of privacy. And of course, in the textbook and the video lecture, there's the reference to the Washington Post and the National Zoo, where a giraffe died. The Washington Post requested records on the giraffe, and the National Zoo replied saying, "We won't give them to you because of Exemption number 6. It would be a clearly unwarranted invasion of privacy." And the student in the blog says this implies that animals have the same rights as people do on these types of cases. Is that correct? Well, it's not as broad as that. This is in the book and the lecture simply to illustrate that bureaucrats will be bureaucrats, and they will follow the rule no matter how ridiculous following the rule seems. So it's not that giraffes are clearly within the protections of exemption number 6 to FOIA. It's that some bureaucrat said, well, it's a medical record, so we're not going to give it to you. And here's an example. It doesn't even happen to happen in Washington, D.C. Some years ago, a Mustang reporter was leaked a copy of a document about a CSU policy. He wanted to do a story. So he contacted the CSU in Long Beach to get an official copy for his story because he was on deadline. And the CSU said, okay, give us 50 cents. We're going to charge you 25 cents a page. So he said, I'll pay by credit card. And they said, no, you have to pay cash. So he said, okay, so I'll go to the cashier at Cal Poly because it's a CSU school, and I'll pay them the 50 cents and I'll scan the receipt and I'll send it to you. I'll email it to you. And they said, no, you have to pay cash in Long Beach, which is completely silly. But it was the rule, and a bureaucrat was saying, we're going to follow the rules no matter how inconvenient it is. The situation was resolved because the editor for the school paper at CSU Long Beach went over to the cashier's office, paid them 50 cents for the Mustang reporter, and then handed the receipt over to the CSU people, who then said, okay, you have this copy of our policy document, and it's yours. Incidentally, the reporter who did that, I had talked to him during the process, and I said, you need to write a story about this. And he said, well, why should I? I said, because this is the kind of thing that people will talk about. It's the kind of thing that people will pick up. So he wrote a story about it, and nationally, people read the story and picked up on it. The reporter is now working in Washington, not just because of that one story, because the reporter is a pretty good reporter and made effective use of public records laws. But that was one of the ways that he generated some buzz about himself. Not a bad thing. The same student in the blog talked about the Terry Anderson story. He's going to do a book about being abducted and being held hostage. And when he requested information on the terrorist group, the government said, well, if you get a signed release from each member, then we'll give you information. And the question from the students is, why are they protecting the documents of the people who kidnapped him? That does not make sense to me. And it doesn't, if you look at that one particular case. But what you have to understand is that a rule exists to protect everyone. Now, here, it just so happens that the rule is protecting the privacy interests of truly bad people. But that's equal application of the law. You certainly wouldn't want to say, well, we'll only apply the law and protect people who are deserving of protection, because who's going to decide who deserves protection or not, especially in the current administration? You may have seen that the president has tweeted that he is going to kick transgender people out of the armed forces. Well, our famous phone system is now acting up, so we'll resume this shortly. Okay, back to what I was saying. The president has now decided that transgender members of the armed forces, people who have been fighting to protect America and its interests, will have to leave the military. They can't stay. And various reasons have been given. One of the reasons that's been advanced is that the military will pay for these members of the armed forces to go through gender reassignment, and the president apparently thinks that he can save $8 million, which would then go toward paying for his famous border wall. The president's spokeswoman, Sarah Huckabee, says, well, it's to protect the integrity of the military, because it's to ensure the integrity of the units, the uniformity, to maintain high morale. Reporters asked her, said, well, how do you know that? Have you looked at any of the militaries? And there are other militaries around the world that have transgender service people. Did you look at evidence from those militaries in coming to this decision? And she said, well, no, we're only worried about American military. So it's not clear what the basis is. But here, the president has decided that this group of people no longer is deserving of equal protection. Gay people used to be kicked out of the military, and now gay people can serve openly. And the question is, if you're going to make a rule to protect people's rights based upon who you think deserves those rights, then you're making everybody vulnerable, because people come up with the weirdest things to be upset about. So, the privacy protections, yes, it wanted protecting bad guys, but it protected the bad guys because it protects everybody. Okay, so Supreme Court says access is not a constitutional right under the First Amendment. And of course, the quote from the textbook or the lecture, Congress has to provide us access, and in the states, state legislatures have to provide access. Does this mean certain situations go to the federal level and some to the state? What's the difference? Does the decision on access for each situation vary from state to state? Well, understand at its foundation, federal executive records are covered by FOIA. Federal executive records are not state records. State records are covered by individual state access laws. Each state has its own public records law. Some of them are pretty good, some of them are not so good. And so it depends on the state that you're in. If the state that you're in has a law that says you get access to this one kind of record, then you have access to it. In another state, if they say you don't have access to this one kind of record, then you don't have access to the record. So you have to see what the law is in your particular state. Question came up about the Cold War research, the radiation test, the kids club at the poor school, the kid who was subjected to lethal doses of gamma radiation at Oak Ridge National Laboratories, and in a shouted question, how is that ethical and or legal? Did his parents know the whole story? Did he even have a say? I don't have the records that go into that much detail. I can tell you that ethically, no, it's not the right thing. Legally, it kind of depends. Now, was this murder? They took his life. They took an action that ended his life. The fact that he was dying doesn't really make a difference. If you go to law school and you take criminal law, professors will talk about somebody is dying of a heart attack and they're going to be dead in like an hour. But somebody else comes along and shoots the person in the head and kills them 60 minutes from the time that they surely would be dead. Is that murder? And if you take criminal law, you'll find that yes, it's murder. If you get killed 10 minutes before you were going to die, the person who kills you has taken away 10 minutes of your life and has committed a murder. So, people in government, with the acquiescence of the boy's family, including his parents, I assume, took a deliberate action that resulted in the premature death of this child. Yes, he was going to die. He was dying of cancer, but they caused his death to occur earlier. So, under a definition of murder under criminal law, this doesn't seem to be legal. But you have to remember that at the time, we were in the middle of the Cold War. We knew that the Soviets, the godless communists, would do terrible things if they were ever able to defeat the United States and the rest of the free world. So, yes, sacrifices had to be made, and this one young boy's family sacrificed him to preserve democracy and to protect America. I can't think of any prosecutor I know who would, at the time, have gone after the government. And even if a prosecutor did, I'm not sure you could find many juries who would say, no, we want to put these people in prison or execute them because they caused this boy to die soon, when he in fact was helping to protect us from the godless communists. You'll notice that I said the term godless communists twice. And this is a bit of trivia. And that's a guy riding a motorcycle that's not well tuned up and down the street. Anyway, the bit of trivia. Occasionally you'll hear some argument about America is a Christian country. We were founded as a Christian country, and people say, well, look at the money. It says, in God we trust. That phrase was not on American currency from the beginning. That phrase went onto American currency during the Cold War. It was added there by the government to make clear the difference between the United States and the godless communists of the Soviet Union. So they said, look, you can either ally yourself with these godless communists who are terrible people, or you can ally yourself with the United States, which believes in God. The Pledge of Allegiance, when it was written, did not have the phrase one nation under God. It was just one nation. But that was added during the Cold War so that we would appear to be a Christian nation and therefore more popular with people who were religious. Just a bit of trivia if you ever get into a game or someone starts spouting nonsense about how Christian America was from the very beginning. So, back to the question. No, I don't think it was legal. No, I don't think it was ethical. But I also don't think that anyone would be prosecuted for murder in that case. A similar question, the open-air nuclear test, and people are harmed. Do only the individual at risk have the right to sue, or can groups concerned also sue on the basis of harm to public welfare? This brings up two things. The first one is the nuclear tests were conducted by the U.S. government, and you cannot sue the U.S. government unless the government agrees to be sued because of a notion in the law called sovereign immunity. Sovereign immunity says that governments can only be sued if they consent to be sued. It comes to us from British common law, and the notion was the king could do no wrong, therefore the king could not be prosecuted and the king could not be sued for the result of the king's decision. Now, in the United States, sovereign immunity is typically applied to the federal government and state government. It doesn't apply to lower levels, like cities, which is why if a police officer in Chicago shoots and kills a young man who is not a threat, the young man's family has the right to sue the city of Chicago. Now, the Federal Tort Claims Act makes it easier for the federal government to agree to be sued, but no, you can't sue for that. There were people who were affected by the nuclear test. There were the members of the military, and then if you've ever spent time in Utah, Idaho, or Nevada, you'll hear about the downwinders. These were people who were downwind of the nuclear tests who were harmed by the fallout because it blew downwind. They could not sue because of sovereign immunity. The people in the armed forces could not sue because of sovereign immunity. And so those people who wound up getting cancer and dying, they simply went to Congress and said, we're the downwinders, or we're the atomic veterans, and we think that we've been treated poorly. We would like some compensation. And Congress has passed measures to provide some compensation for the nuclear veterans and for downwinders if they can prove that they were harmed by the fallout. But there's no lawsuit. Second part of the question that I didn't necessarily want to cover in depth as much involves the notion of something called standing. S-T-A-N-D-I-N-G, standing. And to understand standing, you have to understand that if you want to stand in front of a federal judge and make your case, you have to have a legal right to be there. You have to have standing. Standing means that you have an interest in the case because you were affected. Your rights were affected. If somebody decided to sue because of the open-air nuclear tests, and that person was a downwinder and said the fallout blew downwind, it blew over my ranch, it killed all my horses and cattle and chickens, and it has killed my family, and I have cancer and I'm going to sue, that person, as long as the federal government waived sovereign immunity, could sue because that person had standing. That person had a real legitimate interest in pursuing a case. Now, if you were somebody living in New Jersey who said, well, the government did these open-air nuclear tests and a lot of people were harmed, I'm going to sue the government on their behalf, the court would say, get out of here because you do not have standing. You don't have a personal stake in what's going on. So that's why we don't have a lot of cases where people say, I don't like this policy of the federal government, therefore I'm going to sue for people who are affected. I'm not being affected, but I'm going to sue for these other poor people. You can't do that because you don't have a horse in the race. You don't have a dog in the fight. You have to have standing. Okay, yes, it's a confusing section of class. Cases have gone different ways. It seems it depends on the state, and it's scary not only in terms of the test, but this person who's going to be a professional communicator. And I will agree, it is scary. We have FOIA, the federal statute, and federal judges will interpret FOIA in different ways. Some judges are very deferential to the federal government, and if the federal government says we don't want to give this record to you, they'll say, okay, the federal government doesn't have to do anything. But the decisions by these federal judges are reviewed by appellate courts. And ultimately, as in the McBurney case, the Supreme Court, and regrettably you saw how Justice Alito turned Professor Cross's arguments for the public's right to know on its head, even the justices don't get it right all the time. At the state level, if a state agency or state entity won't give you a record, then you sue in a state court, and you have to hope that the judge you get understands the law, number one, and number two, believes in the public's right to know. Now, one of the things about media law is that a lot of the things we deal with in media law, most judges don't know much about it. That's not what they deal with. They deal with lawsuits over contract claims. They deal with crimes and misdemeanors, felonies, and such. And they don't know about the First Amendment. When I went to law school, I was unusual in that I took every class that related to constitutional rights, including the First Amendment. I didn't take the standard wills and estates. That's the law regarding the property of dead people. I didn't take oil and gas, which is the law as it relates to the ownership of oil and gas rights. I didn't take state civil procedure. I took Constitutional Law 1, Constitutional Law 2. I took our copyright class. I took the class on First Amendment. I took the class on legal history. So I don't know much about what most lawyers and judges know about, but I do know about things that most lawyers and judges have no clue. And sometimes the judge sitting on the bench will say some really dumb things simply because the judge doesn't know the law regarding the First Amendment. So yes, it's tough. Judges make bad decisions. You just have to know what the statutes mean, and you have to know when the Supreme Court has ruled what the Supreme Court has said, because the Supreme Court is the final, has the final say in legal controversies. For the test, depending upon the role you're assigned, in the sample question I gave you, where you were either the reporter, the FOIA officer, or the judge reviewing a decision about records, you apply the statute. Or you apply cases where the statute failed to operate. Forsham versus Harris, right? The Department of Education didn't have the record that was being sought by reporters, so the judge said, well, they can't give you what they don't have. So keep that in mind. The exemption for law enforcement and criminal investigatory records. Do police records not apply under the exemption? You have to understand that federal law enforcement is covered by Exemption 7. Police records, normally what we think of police, we're looking at state and local agencies. They're subject to a particular state's open records law. So it depends on the type of record being requested, either state or federal. Now, I've said that most state open records laws are derived from FOIA. There are some states who had that had open records law before FOIA, but for many of them, their open records law have been guided by the way FOIA was written and how FOIA was interpreted by the federal courts. So most states, California included, will exclude police investigatory records simply because it doesn't make sense to let people get copies of police investigations, especially if it's the person who's being investigated. So if you're filing a request with the SLO PD, you have to look at the California Public Records Act. If you're filing a request with the FBI operating in San Luis Obispo, then you file a request under FOIA. In each case, CPRA will protect some of the state police records, and FOIA will protect some of the federal police records. Right, different states have different laws. Does that mean the cases can be only used as precedent for similar cases in the same state? And the question is, should I avoid using a case from Florida as precedents for a case in New Hampshire? So, generally speaking, that's correct. Each state has its own open records law. Each state follows its own open records law when cases are brought. The state law is the key. Now, having said that, having looked at public records cases brought in states, often, not all the time, but often, a judge deciding the case will say, here we have this controversy, and a similar controversy was resolved in our neighboring state. And I like the way the judge in the neighboring state resolved this, so I'm going to apply that principle, because that principle can be applied under our state access law. Now, if a judge in another state applies that state's access and it's completely opposite of the state law where the case is being tried, then the judge will not use that out-of-state decision. It's an interesting thing. I was involved in a lawsuit not too long ago where the opposing counsel said, well, I don't like your argument because it comes from a different state. And the judge agreed with the opposing counsel. And then in their case, they said, well, we have these cases from other states that stand for the principle that my guy's right. And they didn't acknowledge the hypocrisy in saying, well, I'm not going to let you try to bring in this other state case when I'm going to bring in cases from other states myself. For the test is not going to be as confusing as that. You will either have FOIA cases in which FOIA will apply, or you'll have a state case in which California Public Record Act will apply. So just keep those separate, each one applying in its own backyard. So how does FOIA work? Don't the states also need to abide by the statute to ensure that people have a right to obtain access to federal agency records? Okay, FOIA applies only to federal executive agency records and information. It does not apply to the individual states. Each state has its own access laws. State access laws do not apply to federal executive agencies. If a federal executive agency receives your request and turns you down, you don't get to go to the state district court. You have to go to federal court. So the states cannot ensure that FOIA gives people records because they don't have standing. Hawks versus IRS, since auditing is a public matter, how do courts determine whether a business or other entity are dealing with public matters? How many people need to be affected to deem it a public matter? Well, first off, the courts will not look at businesses in a FOIA setting. FOIA applies only to federal executive agencies. So exemption number 2, which says internal personnel rules and practices of an agency in which there is no public interest do not have to be disclosed. This applies to internal matters of a relatively trivial nature. That's how the courts have analyzed this. And so the question for the FOIA officer and the reviewing courts is whether the requested information really is trivial. The Hawks law firm wanted a copy of the Internal Revenue Service auditing manual. There is nothing trivial about an IRS audit. If you've ever been audited or know someone who's audited, you will know that it's a terrible time of your life, months in which you have to provide every single scrap of information, every possible record to justify your information on your tax return. And they want to look at every damn piece of paper. So when the Hawks requested the auditing manual and the IRS came back and said, oh no, this is an internal rule, this is an internal practice, nobody cares about the auditing manual, the federal judge hearing the case was shocked. Really? You think no one's interested? People are deathly afraid of being audited by the IRS. It is too a matter of intense public interest. It is a public matter. And so that's why the Hawks law firm won its case and got the IRS auditing manual. For other agencies and other records, it's going to be decided on a case-by-case basis. If you want to find out how the Department of Defense handles cafeteria trays in the Pentagon, that's probably going to be trivial. Who cares where you stack the used cafeteria trays? But on the other hand, if you're investigating corruption and waste in government, and you want to know how many times they use a cafeteria tray before they throw it away and have to order a new one at $500 a tray, well, that would not be trivial if you could make that argument and convince a court. When did FOIA come into play? Did something happen to encourage lawmakers to come up with FOIA? FOIA came into play in 1966 when Congress passed it and President Lyndon Johnson signed the bill into law. Before FOIA, disclosures of records and information from federal executive agencies was governed by the Administrative Procedures Act. In fact, the Administrative Procedures Act is still around for a lot of functions of the government. And it was not a good act for providing for transparency and public accountability, because under the APA, you could request a record from a federal executive agency, and the agency was allowed to say, no, I'm rejecting your request for good cause. Now, the key here is that the agency didn't have to define what good cause was. And if the agency decided that for good cause they weren't going to give you the record, they could also deny you what good cause was. So, well, we have a good reason for not giving you the record, but we're not going to tell you the reason. If you ask us for records about the reason, we're going to tell you we don't have to give them to you because there is good cause. It was a system that was destined to keep people in the dark. So journalists and scientists advocated for transparency and openness. The scientists who wanted to be able to share information, journalists who wanted to be able to cover government and carry out their watchdog function. And they managed to convince a majority of the House and the Senate that transparency in the federal executive was a good thing. Now, you'll notice that the House and the Senate are part of the legislative branch, which is not covered by FOIA. So it might have been an easier decision for them to make. But 1966, and it was there because people were complaining that the Administrative Procedures Act kept everybody in the dark. Can just any average person access someone else's record without a reason? When they access these records, do they need to state what they're using them for? You don't have to have a reason. It is a public record, which means the public is entitled to it, and everybody in the public is entitled to the record. Now, decades ago, when I was head of a state group in Oklahoma advocating for greater public access and trying to make sure that local governments obeyed the law and gave information and records to people when they requested them, I had to deal with government officials who treated the public records in their custody like their own private papers, like their own family albums. They wanted to know what people were going to use the record for, and if they didn't like the reason, then they sure as hell was not going to give it out. And I had to make arguments and sometimes threaten lawsuits and telling them that's not the law. The requester does not have to supply a reason. The requester does not have to explain how the record is going to be used. It's a public record, and so the public has a right to know. Now, you may be thinking, well, this means that somebody could find out stuff about me and then make it public. We could have doxing going on, D-O-X-I-N-G. And yes, that's a possibility. It's part of the cost of transparency in government. And those exemptions, the ones that protected the information about the Hezbollah kidnappers, well, what protected them also protects you in terms of the federal government disclosing a matter which would be a clearly unwarranted invasion of privacy. State access laws generally have similar provisions. So, on the one hand, it's terrible that people's secrets are being protected, but on the other hand, it's great that your secrets would be protected. The law treats everybody equally. Here's a blog about the Missing 411 movie. The premise of there was a book and then there was a movie saying thousands of people go missing in national parks. And the book and the movie say that the Park Service is, at best they're negligent, at worst they're part of some nefarious and dark scheme, and they won't provide information about how many people are missing. And the question is whether the student believes in conspiracy or not. Shouldn't the public have access to such a database if it's a growing phenomenon? For many journalists, the trail goes cold. Well, the National Park Service has a cold case page. On the cold case page, it makes reference to 22 persons who are missing. That is to say, there are 22 people who went missing in national parks. Thousands of people? No. The National Park Service cold case page also has a number of cases where people have been killed, and they're asking for the public to come forward with information to help resolve those cases and find the person who committed the crime. Incidentally, when you are looking at something where a book threatens to expose everything and tell you about the bad acts that are being committed and the government's covering them up, you should go to Snopes.com. It is the premier debunking website. It's been around for many years. Now, there's a discussion thread at Snopes.com about the missing 411. And people who are commenting, not necessarily the Snopes.com folks, but people who comment on the conversational thread, note that the person who wrote the book and made the movie is also a Bigfoot exists advocate. That is to say, he says Bigfoot exists and Bigfoot is out there, and they suggest that the credibility of this person may not be great because of this Bigfoot argument. Bigfoot is of some interest to me because I used to teach at Idaho State University. And Idaho State University is where Professor Jeff Meldrum works. And Professor Jeff Meldrum is the preeminent scientist who advocates for the existence of Bigfoot. In fact, I had students who did a mini documentary about Professor Meldrum and his argument that there is a hominid or human-like, ape-like creature that is in the Pacific Northwest that wanders around and has never been caught, that has never been discovered, as in they found a body or was killed by animals or was killed by a hunter. In the years since people have talked about Bigfoot, no one's ever brought one in. So I'm skeptical. And the person who suggests Bigfoot exists, who also says thousands of people, mostly children, are going missing in national parks, I'm skeptical about that. The other reason I'm skeptical about that is I used to cover cops and I used to cover the courts. And for thousands of people, mostly children, to go missing and nobody know about it would mean that every police reporter out there who works in and around national parks would have to be part of a cover-up. Because people would say, hey, my kid is missing. They go to the press. And if it's thousands of kids going missing, they would go to thousands of news sites and thousands of reporters, thousands of newspapers and TV stations. So if that happened, then the reporters and the news outlets would be covering those stories, and we'd have bunches of stories. We'd have thousands of stories about individual people going missing in the national parks, and that is not out there. So yeah, if you visited my office before I left, you might have noticed that I had a book on my shelf called Roswell Case Closed. And you may be familiar with the story that an alien spaceship crashed at Roswell, New Mexico, that the federal government initially put out a press release saying that an alien spacecraft crashed in Roswell, New Mexico, but then they covered it up and said it was a experimental weather balloon. And to this day, people say, yes, aliens landed on the Earth at Roswell. The federal government did a whole study. They said, no, it didn't happen. People are still going to believe that. But that's without a whole lot of evidence. And for the missing 411, I haven't seen the evidence. And I did a quick look to find thousands of reports in the media about people disappearing in and around national parks. Oh, also you'll notice that some of the references are to things that have happened decades ago. Now, if it's a continuing conspiracy, if it's continuing attempt to kill people or to kidnap people, then that means that the evildoers are doing this multi-generationally, which doesn't sound particularly plausible to me. But, you know, as they said on the X-Files, the truth is out there. You might look into it. I'm not going to spend any more time checking it out. Okay, the Privacy Act of 1974, citizens can request that the government tell them what records it has on them. And the question here is about correcting information that the federal government has that is wrong. And the question is, what if you incorrectly correct the information? How do you prove that they were wrong about you? Well, you get your records. You get your look at them and say, no, this is not right. So you send the agency a letter saying, this is not right. And you also provide credible evidence to support your claim that the record is not correct. So if the record says that you were a member of the Communist Party and you joined in 1947 and you're a continuing member of the Communist Party, you might simply send them in a copy of your birth certificate showing that you weren't born until the 1980s and therefore you couldn't have joined the Communist Party in 1947. It's just a matter of providing credible, clear evidence to support your claim. Now, the Privacy Act has a provision that says if the agency won't change the record, you can sue them in federal court. And in federal court, what you're going to have to do is you're going to have to present evidence through the witness box that's legally admissible that shows that the government record is wrong and that what you're saying is right. And if the judge believes you and doesn't believe the government, then the judge can order the agency to change the record and pay you your legal fees. So it's just a matter of being able to present credible information. Question about White House email. So the question is, could a president be sued or impeached for not using the email system? Failing to follow the email rule is not an impeachable action. It's not a high crime or misdemeanor. No one has decided to prosecute any former president who didn't use the email system. And so it's like, you have to do this, but if you don't, what's going to happen? Well, I mean, you get people talking about you. So do presidents face repercussions for not abiding by the Electronic Freedom of Information Act or White House policy? No. I mean, apart from me writing about them not following the rule and then saying in a video lecture that they didn't follow the rule, there's not much. Well, I mean, people will complain about them and say, evidence that this person is a lawbreaker and a bad person and you shouldn't elect them or re-elect them. But it's not particularly weighty. Question about the form of the exam. Will it still be in paragraph form? Do you ever give out any study guide or outline for what the exam will look like? Well, the study guide is read from the beginning of the book or from the beginning of the section to the end of the section. Everything except for the stuff I tell you not to read is fair game for the exam. How much from each section of the class will be on the exam? I pluck questions from my test bank. And I try to make it so that I have enough for you to be able to pick questions. But I don't say, okay, here's the FOIA Exemption 1 question. Because that's not real life. In real life, you make a request and the government says, we're not going to give it to you for these exemptions. So in real life, you have to be able to spot these things. You have to be able to anticipate these things. As I said in the early lectures, there's not a little man waving a red flag saying this legal issue is going to jump up and bite you in the ass. You have to spot the legal landmine before you step on it. So questions, yes. Fact patterns, hypotheticals. and then questions for you to answer about who's right or wrong, why according to the law they're right or wrong, or how many ways they could be right or wrong, and you have to be detailed. You can't simply say, well, they're wrong because the law says you have to do something else. No. You have to show me how the law works. As I always say, it's like a math class. You have to show me the steps to solve the equation, because the tests are the way for you to prove to me that you know the law. That's the whole point of the course. Do you know the law in order to be able to function as a professional communicator or as an informed citizen aware of his or her rights? CIPRA makes reference to the evidence code relating to privilege. Privilege in the evidence code. If you go to law school, you'll take criminal law as a first-year student, and then if you're interested in litigation, you can take a class on evidence, and evidence will cover the law of evidence and the evidence code. Evidence code is the code equivalent to a state statute that says this evidence is admissible, that evidence is not admissible. The evidence code also refers to privilege. Sometimes evidence doesn't need to be shared with defense lawyers. Sometimes evidence held by the defense lawyer does not need to be shared with the prosecutor. Privilege in connection with evidence is a right to keep communications confidential in certain specially recognized relationships. So the doctor-patient relationship carries a privilege. So what the patient says to the doctor, this is how I got my disgusting disease. The state cannot force the doctor to testify what the patient said. Clergy penitent. If a priest hears your confession, that's privileged, and the state cannot force the priest to speak of what was said in confession. The most famous is the attorney-client privilege. What the client says to the attorney is privileged, and the prosecutor cannot put the attorney on the stand and say, well, what did your client say about committing this crime? Because if attorneys could be forced to say what their clients told them, then there would be no attorneys, because no client would trust an attorney with information about the case. So the evidence code protects the privilege from those relationships. So under CIPRA, there are some sections where it said, well, CIPRA starts out with public records are public. Everybody's entitled to them. It talks about when you have to provide the records, how you have to provide the records, and then it says, but some records don't have to be disclosed. And some of the records that don't have to be disclosed don't have to be disclosed because of the evidence code. So the state doesn't have to give up certain things. CIPRA also covered a lot of specific categories that don't necessarily seem to pertain to journalists. Should we focus mostly on learning the bolded segments? The bolded segments I put in boldface to help you, because those are frequently things that come up, not just for journalists, but for members of the public. And you have to understand that everything about the public getting information pertains to journalism, because you're a member of the public. You do work to find information on behalf of the public. So if you go to make a request for records, it's like the person in the next block making a request for records. The difference is you may have a lot more people knowing about what you get than the person in the next block. But it's all about journalism. It's all about accountability and transparency. Okay, blog question. To clarify, in the state of California, you need to submit both a CIPRA request and a FOIA request to get public information. Is this the case for other states as well? Well, in California, if you're asking for records from a federal executive agency, you file a FOIA request. If you are asking for records from a California state entity covered by CIPRA, you file a CIPRA request. And I recommend that students file the appropriate request for everything, because sometimes the federal government keeps information about stuff happening in the states. And of course, the states keep information about stuff happening in their own states. It's kind of a belt and suspenders sort of thing. If you ask for it from both, you may be surprised and get records from both. Is Cal Poly required to disclose a campus rape to students? They're sending out an email about a rape. Does the public have a right to know? The Clery Act, it's in your textbook and part of the lecture, requires that institutions of higher education that receive federal monies make a public report every year about the crimes on campus for the previous year. And one of the things about the Clery Act is some universities don't want to have to say, oh, we had X number of rapes, we had X number of assaults, we had X number of murders. Well, they can't do much about murders. But for rapes, on some campuses, if a student goes to the campus police, a member of the Office of Student Affairs or the equivalent will show up at the police station and say, do you really want to do this? And that person will suggest to the student that if the student pursues the matter through campus discipline, then the student who's the victim of a rape will get justice quicker. If it becomes a criminal matter, then it's going to take years and you're going to have to come back for trials and who knows what's going to happen. But if you report this as a campus disciplinary thing, then we can kick this student out right away. We can sanction the student in a lot of ways. We'll give you justice quicker. Well, they're not really interested in giving students justice quicker. What they're interested in is not having a police report that says there were 20 rapes on this campus in the spring semester, because they have to protect the image of the university. So if they can divert students who are rape victims from going to the police and instead handling it through the campus disciplinary system, then their Clery Act report looks pretty good. Oh, we had one sexual assault on campus for all of last year. Through conversations, you and your friends, I'm sure, are aware of more than one person who's been the victim of a sexual assault. But when the Clery Act comes out, it's like, oh, we're just as safe as your high school. Your parents don't need to worry. Now, with respect to an email being sent out when a rape is reported, the campus provides warnings through email if there's an ongoing criminal threat or an ongoing threat to public safety. Every so often we get a cougar was spotted in some canyon up in the upper part of the campus. Or a couple of years ago, somebody was riding around. Someone was hiding in the bushes waiting for female students to walk past and then running up behind them, reaching up under their skirts to pull down their underwear. Now, this happened to several students because it was an ongoing thing, because they hadn't found the person, hadn't made any arrests. They were saying this is an ongoing threat, so the university sent out emails. So where the threat is ongoing, the campus will provide a warning. If it looks to be one incident, a single crime that is not part of a pattern that is being repeated and repeated, then no, there's no reason that the university has to give people warnings. Other question, are there any criminal investigations regarding students, staff, or faculty? Are we privy to this information? Well, you need to look at police records available to you under CPRA. The other thing you need to do is you need to establish a good working relationship with the prosecutor. Ask the DA. Check with the DA. Are they dealing with cases? Are there crimes that have occurred that are going to the DA's office for the DA either to prosecute or enter into a plea bargain? It shouldn't just be Cal Poly. You should ask campus police, but you should also ask city police, and you might even ask the county sheriff. Ask every law enforcement entity through CPRA to find anything that might implicate a crime involving a member of the campus community. That's how you try to establish what's actually happening. I remember one university would not report crimes under the Clery Act if they could, as they said, not determine if a member of the campus was both the perpetrator and the victim. In other words, they said, oh, it's not a campus crime because somebody from off campus came here and committed the crime and made our campus member the victim. But because the perpetrator is not from the campus, it's not a campus crime, which is a completely wrong interpretation of Clery. But universities are eager to protect their images so that your parents entrust you to the university and they get public support. So a lot of universities play fast and loose with the rules and the numbers. Now we move on to a question about free press, fair trial. Student asked a question about civil grand juries. All right, so you have grand juries, otherwise known as criminal grand juries. They indict or they true bill or no bill defendants. A true bill means they indicted the defendant, and the defendant is going to have to face a trial. No bill means the grand jury says, no, we're not convinced that the person committed a crime, and so, no, this person shouldn't be prosecuted. The criminal grand jury hears evidence presented by the prosecutor and then votes to have the person bound over for trial or no billed and then not prosecuted. The criminal grand jury was created as a check on overzealous prosecutors. It was the citizens would say, no, we don't agree with prosecuting this person. You just want to prosecute this person because you're an overzealous prosecutor. In practice, however, most grand juries do whatever the prosecutor asks them to do, because the prosecutor, after all, is controlling the flow of information to the criminal grand jury. Then we have the separate and distinct civil grand jury. They're made up of members of the community, and what they do is they take a look at government. They see if the public welfare system is doing its job. They look to see how wasteful city government is, but they have nothing to do with the prosecution of crimes. They're simply issuing a report. We think the city is wasting a lot of money on putting doilies on all park benches, and it's costing the city $50,000 a year. We think this is wasteful. Well, that's not prosecution. That's simply saying we're taking a look at the city or the government from an outsider's point of view, and we're coming to conclusions. I have questions regarding how to address the California Public Records Act on the next test. Would you like to say according to Act so Part A, and then go into detail about how that applies? Yes, maybe, kind of. The test is, can you prove to me that you know how the California Public Records Act works, and based upon the hypothetical that I give you, correctly apply the California Public Records Act to the hypothetical and come up with an answer which shows in detail your knowledge and shows in detail how the law works. That's what I'm looking for.